Supreme Court of India Jatinder Kumar Sapra vs Anupama Sapra decided on May 6, 2024 SEC Online SC 796 Facts of the case. The appellant and the respondent before this court were married. Out of the wedlock 2 children were born. Despite being together for approximately 14 years, bitterness crept into the relationship between the parties. Whilst on one hand, it is alleged that the respondent ill-treated the appellant, and constantly acted against the appellant at the behest of her parents. On the other hand, the respondent wife alleged cruelty and torture at the hands of the appellant husband. The family court dismissed a petition instituted by the appellant under Section 13(1)(I) of the Hindu Marriage Act, 1955 seeking dissolution of marriage by way of a decree of divorce. High Court dismissed the appeal. Findings of the court: despite our best efforts, the parties were adamant on parting ways, citing an irretrievable breakdown of their marriage on March 22, 2024. We were informed by Mr. Patwalia that despite his best efforts, the parties were not willing to arrive at an amicable settlement and that there was no possibility of the parties residing together. At our request, Mr. Patwalia placed on a record a short note outlining the details of his efforts, including inter alia the deliberations between the parties in respect of the quantum of permanent alimony to be paid by the appellant towards the respondent. We have given due consideration to submissions made by the respective counsels and the materials placed on record. The undisputed facts of the case reveal that the parties have separated 22 years ago, i.e., having cohabited last in January 2002. The children are now majors and gainfully employed. Elder son is an associate in a dental clinic, and younger son is a video/film editor. Thus, keeping in view the totality of circumstances, we are satisfied that the facts on record establish that the marriage between the parties has broken down and that there is no possibility that the parties would cohabit together in the future. Accordingly, we are of the considered opinion that the formal union between the parties is neither justified or desirable. We deem it appropriate to exercise our discretion under Article 142(1) of the Constitution of India and pass a decree of divorce on the ground of irretrievable breakdown of marriage. We deem it fit and proper that the appellant pays an amount of Rs 50 lakh only to the respondent wife as permanent alimony. The appeal stands allowed in the aforesaid terms. The registry is directed to prepare a decree of divorce accordingly.